everybody. Welcome to this week's edition of the OIG Coffee Table. I'm here with Matt Kachansky. Wade, he was close. He was
We had
close.
him. We had him one week. It
I
was
know.
like
We were
old home
close.
week, and
We were
then
close today, though, Matt, because I think, we had some scheduling issues, so we had to move the timing of this, and I think that created havoc for poor Wade. If he didn't have gray hair, he certainly would now, although you've had gray hair since I think you were 15. So,
pretty close.
yeah, pretty close. You were the guy who was buying beer when everybody else was underage as well, right? Because no one would ever have questioned. They have that thing that says we card for under 30. And you go to buy some beer and they don't card you and you get really like annoyed because you're like, thanks for the obvious. But when you were going at 16 and 17 years old, you weren't
When I
being
had to have
carded.
someone drive me to the beer
Yeah.
store to get the beer.
You were appreciative of it. So anyway, so today we want to talk. So there's an interesting case that came out the other day, and we're not going to focus a lot about the case, but some of the other implications. Company named Veloxis. It was a case out of, I think, District of
Boston.
Massachusetts. Global settlement that involved $46 million, criminal and civil, including ultimately a DPA, deferred prosecution agreement. And look, we've seen these a lot in the pharma space, particularly up in Boston with the charities where they were doing work on the purported charities. And you see these pharmaceutical companies having 3 and 4 corporate integrity agreements as a result of it. And they never get excluded. This was a criminal and civil case. Veloxis's big drug was a kidney immunosuppressant drug for patients that were post-kidney transplant. Right? You have to be on these immunosuppressants for life. So that you don't have a rejection of the organ. And I think that, there's a lot of different immunosuppressors. My guess is that once you're on one, it's very hard to switch to a different one, even if it may be a biosimilar. But the thing that always comes up, so first of all, this was clearly, when they work these cases, they're clearly worked as what they call parallel investigations. There's a civil AUSA, there's a criminal AUSA, and those two are worked kind of in conjunction with each other. The criminal will always take the lead on a case like this until there's a resolution, and they typically will do what they call a global resolution to resolve the criminal and civil liability and kind of be done with it. And then it results from a criminal perspective. There's either a plea of guilty in which it results in probation for the company because you can't put an entity in jail, in prison, and then or you get a deferred prosecution agreement. And I think, the thing that I think gets everybody chapped, and I think rightfully so, is when you see a $46 million resolution of a case and there aren't any other implications, there's no exclusion. Even on a criminal case, there may be, no exclusion. Now, typically on a criminal case, there's going to have to be a mandatory exclusion. But on, cases like this, you usually see that it becomes a deferred prosecution agreement or something to waive that statutory liability. And I think the problem that people globally have is what's good for the goose is not good for the gander. And why is it that your average provider is getting excluded, but in the pharma space they're not being provided? And the example that I love to give is, I remember working on something where we were supporting a case that was out of Texas. It was a pediatrician Medicaid case, and the provider was convicted, got probation, and was excluded, but they had a carve out for a particular zip code, which happened to be the zip code in the county where the provider was. It was a border town, and I think this provider was like literally the only pediatrician in the area. So there's a delivery of care and a quality of care issue. Now, you in your past life, when you were at the OIG, one of your roles in being a SAC over at the headquarters level was that you oversaw the exclusions. And one of the things that always comes up as a discussion point is, why isn't a pharmaceutical company getting excluded? Why isn't a device manufacturer that's been really involved in fraud? Now, the history on Veloxis is, from a fraud perspective, I mean, they were doing all the check boxes, lavish gifts, trips. As I like cash, as I always like to say, short of hookers and blow. Which we don't know, that could have been. But, for those that follow a lot of these cases, and we've had some discussions involving biodiagnostic labs, BLS, that was a case that I had a little bit of involvement with. It was out of the District of New Jersey. It involved a lot of payments of cash and in kind, including renting private jets and taking the top referring docs from the lab to the Super Bowl. And on that jet, they had hookers and blow. And so it's, it's cash or in kind, right? It still fits the bill. So let's talk a little about that. So under federal exclusionary authorities, there's mandatory and permissive. Exclusion authorities on settlements typically would fall under the permissive, and on criminal cases, it's typically mandatory unless you have something like a DPA. But there is an issue that really does get to the heart of it, which is delivery of care and excluding an organization like a pharmaceutical company with a life-saving drug can actually have a really negative impact on the delivery of care to the Medicare, Medicaid, and then collaterally commercial payers.
Right. Yeah, there are a couple dozen exclusion authorities. Two of them mandatory. One is health conviction related to healthcare. This one seemed to get around that because it's a deferred prosecution. Is that considered an actual criminal conviction or not? That's a legal question. And one of the things that's interesting is the company is from North Carolina. It was a quitam that was filed against it. So they filed it in Boston, as we've talked about before, that district being known for successfully handling these types of pharmaceutical case litigation. So that was interesting. Even though everything was in North Carolina, they found venue somehow in Boston to take the case there. But with this is probably because how many manufacturers make this drug that it's equal to what this drug can do, or is it unique? Is it for a certain type of patient that can't take anything else, and is it life-saving? So they probably found a way to have a waiver for the mandatory exclusion, just because there's access to care, quality of care issues involved, and that's happened a lot with exclusions. Case I had against psychiatric hospital chain, they actually created a shell corporation as part of the criminal prosecution. It was the shell corporation that actually pled guilty and got excluded, even though it only existed on paper. They find ways around it to allow the care to go on. Also, many defendants don't want to get an exclusion because that's their lifeblood. So they're going to work, I'll plead if I can get around the exclusion somehow, because to them, especially a corporation, an exclusion kills the business. A criminal conviction costs them money, which they've probably already put aside as, the cost of doing business. And so they work their ways around that to avoid the exclusions. Sometimes it's for the benefit of the patient. Sometimes it's for the facilitating the successful resolution of the case. And as the guy that did the exclusions, we'd have to work with the Department of Justice on how to make the paperwork right so that we follow the law, but not compromise what they were doing in court.
Right. And the thing about exclusions, which a lot of people who, hear about these cases don't fully understand, is that the exclusions team is an entirely separate team contained within the OIG. And I know that there was a period of time when there was a lot of talk about moving exclusions under CMS, and that just never happened. But part of the issue is that the exclusions team needs to independently review certain key legal documents, such as informations, complaints, plea agreements, judgment of conviction, and the like, to be able to identify what the issues were and how those issues fit into the mandatory exclusion language that exists under Title 42, the federal code that governs that. For the most part, exclusions are a mandatory minimum of 5 years, and then there's aggravating factors that can really pump up what those exclusion time periods are. I think the one that sits the worst with people is if the behavior lasted for more than a year, and then you've got potential harm issues and things of that sort that could increase it. And I know that over the years, some of the arguments that have been out there regarding exclusions had to do with sort of the we'll call it arbitrary and capriciousness, in the sense that at the time, in some of the early times of exclusion, two providers who were similarly situated weren't always given exclusion time periods that were the same. And that I think is one thing that people complain about. And then collaterally is the complaint that exclusions don't always necessarily align with the conviction because exclusions can take some time to get resolved.
Yeah, and they've they came a long way in trying to solidify that and make it more consistent. One was the investigations for the exclusions were done by I won't say investigators, but OI, Office of Investigations research analysts. They were exclusion specialists, and they would work for specific regions of the OIG. So we had some assigned to the Atlanta region, the Florida region, all of that. And then the signator for any of the exclusions was the Office of Counsel. So the Office of Counsel would sign off on the work done by OI, and they would make an independent decision whether the information and the documentation provided by OI was sufficient to uphold an exclusion, whether it's 5 years, 10 years. And there'd be lots of discussions back and forth about the length of exclusion if it went beyond the mandatory minimum of 5. And eventually they started to create more and more of specific criteria and requirements to make those decisions. Instead of just being based on the facts of this one case, it was taking a pattern of all of these cases. What's the consistent outcome that would be defensible? So they really worked hard at doing that. But in the beginning, you're right. It was a little bit less. There's a little less conformity.
And I think it's very important for people to understand that the reason why the exclusion process is not as timely as, we see all the time instances where people get excluded. It's like a year later and, they're already out of jail or whatever it may be. But part of it has to do with the fact that exclusions are done by the OIG for federal crimes. They're done for state crimes, but they're also done for potentially state crimes that aren't healthcare focused. For example, you could have a nurse or a doctor that has a non-healthcare related offense that could lead to an exclusion. It used to be that tax wasn't included, but now tax is included, right? So you can have a tax charge against you and still get excluded. And the problem is that oftentimes the exclusion staff isn't automatically notified. So there's a whole process of having to basically troll websites, and it's not a perfect system.
Right. Yeah. And yeah, because they are the ones, there's no real referral process set up. At least when I was there, it was these research analysts going out on the internet and finding these things through press releases, through that point it wasn't social, there was not a lot of social media, but through Google searches and finding things in their respective regions on the state level. The state licensing boards, however, did send us their actions. And so for those permissive exclusions where someone lost their license for specific reasons, they could also take permissive exclusions. And those were a lot of debates between council and us about whether the actions that were behind the reason for the loss of the license fit the criteria of the exclusion. There was always some, because I think one of the big ones was Dr. Kevorkian. Do we exclude him? The answer was, he was convicted of murder, but no, they didn't exclude him. It was the reason for, it wasn't healthcare related. Killing your patient, I'm not sure, but so those were the types of debates we would have.
Right. And so, kind of the summary of this is that while we look at these kinds of cases and they get frustrating, particularly, this one is a terrible one. It was like everything you can imagine. And part of the argument, I guess, I would make is, and I didn't do any of the research on this drug, but my gut is telling me that there is a biosimilar out there, because why else would you be steering so much, to get to them?
If you were the only one, you wouldn't need to do it.
Right. So there must be a biosimilar that was creating some of that, some of that market share softness that, you see on some of these cases. And it is, it's pretty audacious. I mean, they were doing this is like right out of the playbook of the late 90s, early 2000s, right? All of the stuff, cash, lavish gifts, the gift cards, the trips,
Yeah, the
it's like being on an episode.
conferences,
What's
all
yeah,
that
like
stuff.
I mean, this is like you're on an episode of The Price is Right, and you're winning the double showcase showdown because it was cash prizes, 4 days, 3 nights at the lovely Algonquin in New York City for you and a guest.
I remember looking at spreadsheets from some of the pharmaceutical companies where they had the tier of gratuity. You have made these many referrals for the drug or ordered this many for it, you get this prize. If you move up, you get this prize. It was almost
Right.
like the whole Ponzi scheme.
Yeah, and that's that's I think the thing that frustrates people the most is that they're seeing such audacious behavior and there is no, ultimate resolution as to who the guilty parties were. Now there may be some other things that were out there, like, for example, we know that under some of the more recent, within the past 8 or 10 years, the DOJ guidance on, corporate compliance and things of that sort, that the company can't shield or protect the C-suite people. If someone was directing this to happen, and clearly someone at the top knew, that comes out as a result. There's a requirement for cooperation under DOJ, corporate compliance, and just being a good corporate citizen. But it is frustrating when you read these kinds of articles. These articles just kind of slap in the face of what should be considered appropriate corporate behavior and not. And the fact that people need these medications and the fact that doctors are steering the patients towards those medications, right? Now, that becomes a whole other discussion. And this is one of those where we're not even talking about medical necessity. Clearly, you had your kidney transplanted, and clearly you need an immunosuppressant. But I think part of that argument becomes that. Now, one of the things that people should be considering when they're looking at any of this is the open payments website. CMS has had for a number of years the open payments website, the Sunshine Act or something. But when you look at the open payments website, you can see if it's being reported accurately, of course, but you can see when a particular company is paying a provider for something, you can see how much are they paying, what was the purpose of that payment, how much is that company paying in the aggregate. I haven't done any of the research to see what Veloxis was paying overall. It obviously had to be a fair amount of money because they rose to the top, even though this was a key TAM. The fact that there was so much stuff going on, it would have been very hard to hide what that would have been.
And one of the charges against them was falsifying to the government. They have to report that to the government. They falsified the amounts of the gifts to the providers.
Right, because there are limits to how much you can give. And then the other piece of this is what's known as the R-Pharma rules, which is basically the industry rules for compliance that all the pharmaceutical companies are supposed to be following, which put limits on gifts, on dinners, things of that sort. I mean, you remember during a case like Insys, for example, where they were doing dinners in steakhouses, and it would be the thought leader doctor and 5 of his or her buddies having a steak dinner. And the question was, number one, was there even a laptop open for a presentation? And how is it that the signature log showed Makachansky attended 6 dinners over the course of a year to talk about Insys's, Suboxone drug? And how many times do you need to have a talk on Suboxone? But how many times would you like a porterhouse steak for 2? Right? I mean, that's really what a lot of this comes down to. So unfortunately, with things like open payment, a lot of this is you have to troll the systems, you have to go in, you have to look. And then obviously, then the real homework, begins. So for me, reading about this case, it was a terrible case as far as the facts and just the kickbacks and all that. But it's more about, all of these pharmaceutical companies that are under some sort of corporate integrity agreement or under some sort of deferred prosecution agreement or some sort of blank. And then, why is it that they're not excluded as a result of their malfeasance? And really, we have to get to the heart of it, that there are going to be instances where a provider is a niche provider, they're a subspecialty, or in something like this, where taking this company out of the supply chain of the Medicare Medicaid system could really have a detrimental effect on healthcare, as a nation, because Obviously kidney transplants are pretty frequent. Immunosuppressant drugs are needed, and then also the resulting, is this drug used for other things? While there may be generic equivalents for this drug for kidney transplants, the question is this drug used in other transplants for which there isn't a biosimilar and there isn't a generic? Remember, you could have a drug that could have multiple uses, and the patents are going to be for different things. And so the ability to have a generic may be good for one thing, but not another. So, these are all things that have to be considered. So any final thoughts on this? Because I know you ran Exclusions for a while, and I know it was probably your most exciting and fun time.
The last thing is that the exclusions probably scare the defendants more than the actual convictions. They will fight harder to stay in the programs than they will to have a criminal conviction on their record. It's their livelihood. And so making it a bargaining chip is kind of antithetical to having mandatory exclusions, but sometimes it has to be done to get justice done.
Right. Yeah, it's an interesting thing. Unfortunately, these cases just don't go away. And when you see that population is basically being used as trafficked patients without even knowing that they're being trafficked. Patients don't know any better, right? Patients just don't know. They get a prescription from their doctor. The doctor says you need to take this, and they don't think about what are the collateral consequences of that arrangement that existed.
Yeah, there's a blind trust.
Right. It's blind trust. So, well, Wade, I missed you.
I did too.
All right. Well, as always, thanks everybody for tuning in. We enjoy spending the time with you, and we enjoy seeing you guys on the LinkedIn Lives. Again, get the newsletter every Friday to your inbox, as well as getting onto Spotify and YouTube. Just hit subscribe, and you can get our weekly podcast as well as the recordings of the LinkedIn Lives that come on. And until next time, we'll see you on the next OIG Roundtable. Take care.
Thank you, everybody.